Good evening, Advocate Fischer.
Good evening, Chief Justice.
Are you well?
I'm very well, thank you, and good evening to all the other Honourable Commission members.
Commissioners, please. You were interviewed before.
That is correct, Chief Justice.
In your own words, just take a few minutes just to impress us. Tell us why you should be recommended for appointment.
In brief, I find myself involved in a ever-growing, ever-expanding experience of myself as a human being, realizing that for years I have possibly adopted the wrong approach, one of withdrawal and sidelining and being critical and judgmental. And over the years I've come to realize that I need to get more involved. The profession has over the years frustrated me somewhat, as I felt that I couldn't do what I've come to understand is my constitutional obligation, and that is in fact to simply give back what has been given to me over the last 35 years as a legal practitioner. And I believe that having walked that walk, which has involved a lot of spiritual introspection and an understanding of who I am and where I've come from and why I've at times possibly done the wrong thing and taken the wrong road down an incorrect path, I feel it's time that I give back to the legal profession what the legal profession has done for me, and I believe the best way to do that is to comply with what I understand is my constitutional imperative to do that, in honouring especially the legacy of people who are important to me and have played an important role in formulating and maturing me as a human being.
And how else have you prepared yourself for possible appointment ever since your last interview? Where are there areas of improvement, if any improvement was needed?
I can assure you, Chief Justice, there's always room for improvement. I'm forever looking to improve myself. I have a philosophy in life that every person who crosses my path, no matter what their creed or calling, is my teacher. I believe that I must learn from every human being. In the process, I believe I can learn and grow and, in fact, eventually give back to the community. It has, in the process, humbled me and made me realize that possibly for too long in my life I've been somewhat arrogant and somewhat aloof. I'm accused of being that kind of person, although I can assure you I'm actually just a very private person who I believe has grown in the process. And I think I can, in fact, enrich the bench in what is a diverse society that we find ourselves in.
When you say you've been accused of being arrogant, did you get a sense that there may be some truth in that? I ask you the question because I've come across a few colleagues, very pleasant during the interview, but somewhat different after being interviewed in their engagements with fellow colleagues. And they left me wondering, how do they treat litigants if they can deal with their colleagues this way?
Yes, I think I can only, by way of an example, explain my personal experience. And to answer your question briefly and shortly, yes, eventually having come across various people who've said to me, you come across as aloof and somewhat private, I've realized that maybe I do project that image. It is not something I'm proud of. I realize it's something I have to work at, and ultimately I see life as a work in progress. I believe that I don't stop growing at a particular stage in my life. I believe that this is just a new chapter in my life that I am hoping to fulfill. And I am fully aware of what is required of me as a person who would be called upon to sit in judgment of facts and possibly people who have either done a wrong or possibly erred in their civil relationships with each other. I'm acutely aware of that, and what I have discovered is once people get to know me, they realize that I'm not what I appear to be. It's just something that I have to work on as an individual. I can assure you, I've realized that what one needs to do is to have an empathetic ear, listening to the grievances of those who come before you seeking justice and fairness.
You've been in practice for such a long time and a silk for a long time that I am unable to take you through your experience. It's obvious that you're a highly experienced advocate, isn't it?
I have experience, yes. I believe I can bring value to the bench. I have a good relationship with my judge president, and I would like, and that is why I'm here, to be given the opportunity to do that, because I believe that I can add value to that bench in terms of my experience. It's one thing to short track access to the bench and elevation to the bench, but I do believe that I have that experience, which comes from years of exposure, first as an attorney and then for the last 30 years as an advocate.
And finally, as you indicated previously, Bram Fischer was your uncle.
Yes. Revered. What can I say? I can never be Bram Fischer. He's a unique human being. I've often wondered about him, and I've spoken to people about what he was able to do and what he was capable of doing, in fact, what he did. And I suppose in starting to contemplate and meditate upon these realities, I came to realize that it was very simple. The preamble to the Constitution, on which the very foundation of why and for what reason we're all here, obliges me to honor people like Bram Fischer. And I can't think of a better way to do that.
JP?
Thank you, CJ. Advocate Fischer, you've acted in our division for 14 months.
Yes.
And you previously acted in the Eastern Cape for 3 terms.
That's right.
According to your CV. How long does it take for you to produce a judgment?
I had a look at that in preparation for this interview, and I see that there was a single judgment that stood over for about 6 or 7 weeks, and the only reason being is that the advocates appearing before me asked to hand up written heads of argument, and I believe the written heads of argument were only delivered during the Christmas recess. I'd gone on holiday already, and I got back the middle of January, got the heads, and delivered the heads by the end of January. By and large, I believe it's imperative that judgments be delivered as soon as possible, and I think my average must be 3 to 4 weeks maximum.
Thank you. You've had occasion to do circuit court duties, isn't
Yes,
it?
yes.
What's your experience of the manner in which circuit court duties are allocated?
Well, I believe that all judges of the division, acting and permanent appointees, should be prepared to do circuit court, and I have come to experience your division of the work and allocation of the work as seeking to achieve that, and I think without favor or fear of spending time away from home, we've all done that. It's part of the job we do, and I believe it's imperative that we all do that as part of our ongoing exposure to the people in the countryside and giving them access to justice. It's something I support unconditionally.
You have had occasion to do pre-trials, haven't you?
Yes.
So you have been involved in case management.
Yes.
And do you think that it is useful?
I think if properly managed, absolutely. In Bloemfontein, the pre-trials are held on a Monday afternoon. And I think if the judge allocated those pre-trials prepares, it can be very useful and fruitful. In fact, my experience of the way case flow management is managed in the Free State is that, if anything, the attorneys are complaining that trial dates are allocated too soon, which is a tremendous achievement as far as I'm concerned, because we all know that justice delayed is justice denied. And I think it's a winning recipe in the Free State. I don't know how well it would work in the bigger divisions, but most certainly it works in the Free State.
Thank you, CJ.
Thank you, JP. Premier?
Thanks, CJ. Afternoon, Advocate.
Afternoon, Premier.
With the challenges of transformation in general, in terms of transformation of society, and in particular of the judiciary, what will be your contribution to fighting racism?
I think we're all individuals, and ultimately we bring certain values to the bench that are particular to us as individuals. I have, through the path of growth and awareness that I've been walking the last couple of years, come to realize that we've simply got to transform society, and more particularly the mindset of the individual. I believe I have a matured mindset. I believe I have overcome many, many obstacles that were ingrained in me as a young boy, a young man, dealing with my fellow students, first at varsity and then later on as a professional. And I've come to realize that the transformation of society involves primarily the transformation of the individual who believes he or she can add value to that society and serve that society. And ultimately, as an aspirant judge, I see myself as a servant of that society with what I believe is a liberated, what I believe is a progressive mindset that has overcome what I believe are those aspects that drive us apart. And I would rather focus on those realities and aspects that, in fact, draw us together as human beings. I like focusing on the fact that we're all human beings primarily before we would happen to be male or female, black or white.
Thank you, Premier. Commissioner Nyambi?
Thank you, CJ. Afternoon.
Afternoon, Commissioner.
When responding to CJ, you talk of a short track to the bench. What is a short track to the bench? What is that?
What I mean is that I found that being exposed to the law for the length of period I have, I can bring a lot of experience to the bench. I believe that in order to achieve proper transformation, one cannot, like in my case, expect a suitable candidate to spend 25 or 30 years preparing for the bench. And that is why I'm a great supporter of educational programs for both aspirant and serving judges. And I'm mindful of the fact that, in fact, even serving judges would be exposed to sensitivity training, because I think some people simply just don't realize what the iniquities of the past have done to this fractured society. And I believe that we have to exercise extreme patience, extreme compassion, and extreme awareness of the need to transform. We talk about race, we talk about gender transformation, and I support it unequivocally. We can't continue down the path that we did until 1994, and it has to be moved along at a greater pace, failing which the public at large are going to lose faith in the judicial system and have no trust in it.
Are you able to speak any African language?
No, I'm afraid not, and it's possibly one of the most embarrassing and, should I say, unfortunate realities of my life. I wish I could change it. I don't know how to change it at this stage in my life. Many years ago, I thought I was a clever little man because I spent a lot of time on my grandmother's farm, throwing stones and swimming in the dam and shooting with a catty, and thinking, well, at least I can let off a couple of little cursing phrases in Sesotho, but I'm so sorry I didn't learn a language, because that would enable me to understand people better.
You were also referring to just basic greetings.
Yes, things like that. I can't begin to brag about it. I wish I could apologize to the nation at large. I think it's a great, great pity that we aren't obliged to learn several of these African languages. So we'll get to bridge the fear and the uncertainty that a lot of us possess.
What are you doing about it?
What am I doing about it? Well, at my age, I have just come to accept that I will never master a language to the extent that I could conduct a consultation or even a court case in an African language. And I would like to suggest that the best way forward is to accept that in order for us to engender trust and faith by the population at large, they should be given access to the language of their choice, knowing that their version of events would be properly interpreted and placed before the judicial officer. So to that extent, I can only say that's all I can rely on, and I'm deeply sorry about it. I wish I could answer a question like that.
How can language, gender, and race legitimize confidence in the judiciary?
Well, I think as far as race and gender are concerned, obviously the more representative the bench is of the society it professes to serve, the more legitimate and accepting it would be in the eyes of the public at large. And I can't begin to think how an individual must feel if they are confronted with a judge who doesn't begin to understand them, who doesn't even look like them, who doesn't even sound like them. And yes, to that extent, I once again am deeply regretful of the fact that I can't speak a language of the African continent. But I do believe that in having the bench more representative of the demographics of this country, it would instill more confidence and faith in the ordinary man in the street.
Lastly, you are aware about the demographics of the division of the Free State High Court?
Yes, I think I know what the numbers are, Mr. Commissioner.
What will be the advice to the JSC to be able to advance what we have just explained?
Well, if one has regard to your constitutional imperatives, if I understand the relevant section, I think it's 174. The phrase there is to be broadly representative, and I emphasize the word broadly representative of both race and gender, which in my humble submission means that there is room for something less than a mathematical exactitude. And I would think that even if this austere commission decided to appoint somebody like me, I could pursue and advance that perception of a broad representation, notwithstanding the fact that I'm a white man. I can't negate that reality. I am what I am, and that's all I ever can be. But I do believe my mind has grown up.
Thank you, CJ.
Thank you, Commissioner. Maybe before you get into trouble, let me just afford you the opportunity to clear the following. You learn a language you don't know to communicate with those who speak it. Am I right?
Yes.
If you wanted to learn some swear words, what did you want to do with them?
I'm probably going back to when we were 7 or 8, and my friends of then, a fellow by the name of John and his brother Mackenzie, man, they taught us things that I'd love to talk about, but I don't think this is the right time or place to do about it. And whether we were shooting turtle doves or mossies with our catties, and if you couldn't hit a bottle at 50 paces with an arm-thrown stone, you were told in uncertain Masutu terms what an idiot or pathetic fool you were. And whether we picked up cow dung to help the parents with the floors of their houses, those words came naturally and they rolled off our tongues. But I promise you, I'm not trying to suggest that I can begin to communicate other than to possibly exercise or offer an expletive. And I've long since stopped that because I don't think swearing is an appropriate pastime for an advocate.
That's why I'm affording you the opportunity, because so many years later, you remember that you did make an effort to learn the language, but you were very specific about your area of interest. So I'm just saying, to what end did you want to be favored with that vocabulary?
Now, I can assure you, as a senior advocate sitting here, that the last thing I want to be known as is somebody who swears and curses. It's really something I don't promote. In fact, I don't use those words anymore. And I can assure you, I think it's simply just not proper and right. It's not in keeping with the type of propriety and integrity that's expected of somebody who's aspiring to the bench.
I was only trying to afford you the opportunity to clear it in advance, because I've got a long list of commissioners here. Judge President Mlambo.
Thank you, Chief Justice. Good afternoon, Advocate Fischer.
Afternoon, Commissioner.
Advocate Fischer, you obtained silk status in 2011, am I correct?
That's right.
And have you ever taken pupils?
Not as a silk. Somehow our practices don't justify that. But I can assure you, in the 25-odd years before that happened, on a frequent basis, what I do at this stage, or what I'm called upon to do, is to help with so-called advocacy training in preparation for the annual exams. And
well, I think my question is, have you ever taken pupils, whether it's silk or before?
Yes. Not as a silk, but before that, absolutely.
And how many do you think you can count?
I would think about 6 or 7, not more than that. And I found, if I just might adumbrate, we found as our practices progressed away from your classic unopposed motion court, we were approached less frequently to make ourselves available, simply because our practices didn't justify a junior who wouldn't be exposed to the normal run-of-the-mill matters that juniors should involve themselves in.
Well, you wouldn't normally take a junior to an unopposed application, would you?
No.
Yeah.
No.
Well, let's just stick to the question. Asked you whether you've taken pupils. You've said 6 or 7.
Yes, over the years, yes.
Well, I'm just interested in your transformation credentials. How many of those 6 or 7 were black?
I think in possibly 2. Yes, I think 2 of them were. But the Free State hasn't had that many black practitioners, and I think by the time their numbers increased substantially, well, to the extent that we've maybe got 7 or 8 black members, I was already of such a status that I wasn't approached. The Bar Council would simply allocate a pupil to a colleague, and I was found I was outside of that parameter.
So you say 2 of Possibly 2.
Yes, yes.
Do you remember them? Who are they?
I can't. I'm sorry, I can't remember.
You can't remember them?
No, I'm afraid I can't.
Okay, let's leave that. As a silk, you've led legal teams in matters. Am I correct? Like you are the leader in a matter.
Yes, it doesn't happen as frequently in the Free State in terms of having a brief in which you are then given the freedom to draw in juniors.
It's easy to deal with. Sorry, disturbing.
Yes.
It's easy to deal with. Have you had matters where you've had juniors or not?
Yes, I have.
Okay.
Yes.
And what race were those juniors?
I don't want to take credit for this because it was simply by virtue of my instruction. Most of the instructions emanated from the State Attorney's Office, and I was instructed on the basis that I would draw in a junior from the ranks of my black colleagues.
Right. So you've had black juniors?
Yes, yes.
It's not a difficult question.
Yes.
I just asked you whether you've had black juniors
Yes,
or not.
yes.
How many silks do you have in the Free State Bar?
Could you give me half a minute, please? I think there are 8 silks. I speak subject to correction, but I think there are 8 silks.
Is there black silk?
No, there are no black silks.
Okay. What's your view about briefing patterns? You see, I'm asking this as head of a court.
Yes.
We want to draw practitioners who will reflect the demographics
Yes.
of the country to instill confidence in society.
I understand that.
Yes.
As far as briefing patterns are concerned, I must be very candid. My experience of your private sector briefing patterns is that they brief far more of the white colleagues than the black colleagues. As far as your government institutions are concerned, there is, I believe, a program in place to brief more of the black colleagues, and that is my experience in Bloemfontein at this moment in time.
Thank you very much. Thanks, Chije.
Thank you, JP. Commissioner Schmidt.
Thank you, Chief Justice. On page 5 of your questionnaire, you indicate the cases which you have appeared, not more than 10, which you regard as being the most significant, and why. Now, I've already indicated that you've been an advocate for 30 years.
Yes.
And it's disappointingly brief to the extent that it's nearly vague. A case, you cite the following: a case involving contempt of court in facie curiae, which
Yes.
was finalized in the ECA, then the Schifrin principle, and then with regards to Lesotho Highlands Water Development Scheme.
Yes.
I would have expected a more elaborate and a more precise and a more concise indication as to how you've been involved in cases with some significance.
If I can be very blunt about it, the Free State has its own unique type of litigation. And my experience, firstly as an attorney, where I had clients based in Bloemfontein who eventually moved head offices to Johannesburg for argument's sake, and later as a member of the bar, we simply lost those clients, which is a great pity in terms of the exposure and the experience it could have provided for practitioners. You simply found that your major corporates were briefing the Johannesburg and Pretoria bar and bypassing Bloemfontein. And it has a negative spin-off in that even with briefs emanating from state departments, because there aren't any black silks in Bloemfontein, they would frequently and still do brief black silks from as far afield as Cape Town. And it's understandable that such silk would say, look, I'm not prepared to work with a junior from Bloemfontein. I want to work with a junior from my seat. And in the process, we find that the Free State practitioners are sidelined. And that has been an unfortunate reality, and I think it's dictated by commercial reality and experience which has negative spin-offs for Bloemfontein and the exposure we have.
The last thing I'd like to ask is on page, I think it's page 9 of your questionnaire, you give quite, and I'm not going to read it because I don't think it's necessary, but you give quite an expose as to your life journey as to how you reached to a point where you are at the moment.
Yes.
And I'd just like to indicate, and I think that's just to raise the issue once shortly, and you basically say that in keeping with what was later to be a spiritual awakening, I came to realize that if I was true to myself, I had more in common with Africa and its peoples, soil, colors, and sounds. And then eventually I thus regard myself as an African.
Yes.
But in regard to that, I would guess about 10, 12 paragraphs, I would just like to ask you, in light of that, you still did not think it worthwhile or necessary to undertake a study of an African or an indigenous language. So, you know, what I'm trying to say is, it's one thing to talk. It's one thing to indicate some form of objective measure, which you need what you've said to compare it to an objective measure. And I'm asking you, was that your best answer with regards to what you stated here and your failure to learn an indigenous language?
My simple experience was that as one gets older, it becomes more difficult to learn a language like that. And I didn't see it as a stumbling block because I've simply adopted a mindset and a lifestyle where I communicate with and attempt to overcome differences with every single person who crosses my path. I'm now accused of possibly being too familiar because I believe that it really begins with the individual, and it's my life's mission to convince whoever I come into contact with, whether he's putting diesel into my motor car or debating an issue with me in a court, is that we're all human beings and we all have so much more in common than what is focused on, namely some of our differences. And yes, I do regret that. I can't deny that. I really wish I learnt an African language. It would have made me a better person.
What do you mean you are being accused of being too familiar?
I have this habit of seeking to communicate with every individual, whether I'm in a restaurant or whether I'm at a filling station or whether I'm in a shop, or even when somebody's knocking on my window wanting to beg for money. I simply try and communicate to that person that, hello, we're all brothers and sisters. I'm not about to lecture to you or tell you what you should have done right or what you're doing wrong with your life. I found that what I'm really trying to do is to enhance the individual's dignity and self-respect. And I can't stop doing that.
Is there a particular group of people in relation to whom a concern about the familiarity was expressed?
No, in fact, my probably most vociferous critic or protagonist is my wife, who says, just shut up now, man, and you know, stop talking to the people. And it's an ongoing problem I have. She believes I talk too much to whoever crosses my path.
Thank you. Commissioner Nokesi.
Thank you, Chief Justice. Good afternoon.
Good afternoon, Commissioner.
Yes. I understand that you acted in Mthatha around about 2003. Was that when Judge Somyalo was the judge president there?
Yes, whom we had acting was Judge Peko.
Oh, yes.
I seem to recall him, and then later on Miller took over.
Okay.
And then later on Chris Yafta.
Okay.
Yes.
Thank you very much. Obviously, you must have enjoyed Mthatha. You must have enjoyed Mthatha.
Well, it's a unique part of the country. In fact, I couldn't believe how beautiful the Eastern Cape is. I must tell you that.
Yeah. I would have loved to read your judgment. I mean, among the judgments that you have attached here, the one that was delivered on the 17th of March, but you wrote it in Afrikaans. You know, among the judgments that you have attached is written in Afrikaans.
Yes.
What is your view with the proposition that court language, at least document general, I know Afrikaans is an official language, part of the court, that they must be at least in English? What is your view on that?
I don't stand in the way of that at all. I think it creates uniformity, and I am mindful of the fact that a lot of the judges and practitioners are not very adept at Afrikaans. I feel sorry for those who are passionate about Afrikaans, but possibly we have to strive for a pragmatic, middle-of-the-road approach, and I really don't stand in the way of English being the lingua franca in our courts. Yes, I am concerned about the perceptions. I am concerned about what the man in the street thinks, or the woman in the street thinks, about the fact that the court is predominantly an English-speaking forum. But hopefully that can be overcome with qualified interpreters assisting them in advancing their case.
Just recently, you're sort of regretting that you cannot speak indigenous languages, for instance.
Yes.
Meaning that you would like to communicate with them, you would like to reach out, particularly as a judicial office. Now, when your judgments, just as recently as 2011, would still be in Afrikaans, is there any attempt to reach out and make sure that your communications everybody is able to understand, because that's how you communicate on these judgments?
I think until possibly 5-6 years ago, I was of the view that I should write a judgment in the lingua franca of the parties litigating in front of me. And for that reason, I would write some of those judgments in Afrikaans. I must be frank with you, I'd prefer to write them in English, because I'm far more at home in English. But I felt that when the advocates are addressing me in Afrikaans, when the witnesses are testifying in Afrikaans, I almost feel compelled to deliver the judgment in Afrikaans. I have subsequently changed my mind.
Thank you.
I'm now no longer doing that.
Lastly, what is your view on the accountability of judges, that is judicial accountability, in relation to the independence of the judiciary?
Well, I think accountability is an absolute necessity. At the end of the day, judges are not only accountable to the office they hold, they're accountable to the people they serve. And I think that is why it's so important that over and above the type of characteristics that judges have to have in terms of their integrity and their impartiality and their propriety, they have to be accountable to the people who've come to them for redress, who've come to them to resolve their problems. And I think at the end of the day, if one wanted to embroider upon this debate, one could get down to what is in essence the rule of law, and how judges, as part of a judiciary, are there to protect the rights of the individuals.
Thank you, Commissioner Nokesi. Commissioner Malema.
Thank you very much, CJ. The customary marriage thing, when did it come? When did it become a law?
If my memory serves me correctly, it was sometime in the year 2000. I know it was promulgated in about 98, but I think it only came into operation in 2000.
It was a completely new thing to you, right?
Well, I think it was a necessary thing, but yes, it was a new law, absolutely.
No, I'm asking, was it a completely new thing to you?
The Act. Yes, the Act was a new thing. There hadn't been an Act like that before.
Customary marriage?
The Recognition of Customary Marriages Act.
Customary marriage?
I was aware of the fact that that took place, yes.
But it's not something you learned at school or anything. You just came to be more familiar with it when it became an act.
Yes, Mr. Commissioner, I'll be honest with you. At school, we were never taught about it, and at university, we did this strange subject called Comparative African Government and Law at UCT, and in fact, all they did is focus on every government except the government of South Africa, probably for obvious reasons. But we were taught about Ujamaa socialism and things like that. But no, not as a practitioner and not in my studies did I ever come across anything relating to this.
And now you know it, customary marriage, you know it. There is law, you know it.
Well, there is a law, yes, I'm aware of that.
And you know it because you've got interest in it, right?
Well, it's a law that I have never been called upon to adjudicate upon or in fact deal with. I'm aware that it's a law that recognizes customary unions. It's a law that in fact stipulates the requirements for the validity of such. It sets out the proprietary interests of the parties, and I believe it also deals with the manner in which such unions are terminated.
Me and you are going to take a very long time if you're going to answer the questions I'm not asking, because with the hope that I'll move from the question.
I'm sorry?
I'm saying you now know it, despite the fact that it was not taught at school. And
Yes.
it came very late in your life, 2000.
Yes.
Because you've got interest in it, right?
In any law that affects the people of this country, yes, I believe I should be
The same
aware.
way the languages affect the people of this country.
Yes.
Why are you not knowing the languages? Because they affect the people of this country.
It's something I deeply regret.
And I'm trying to demonstrate to you that it's not true, that it's not difficult to learn a new thing, as long as you've got interest in it. You know customary marriage now because you've got interest in it. You can learn the language even if it's late at your age, because you've got interest in it. As long as you have interest, you can learn.
You could say that.
So do you agree that you don't have interest in learning our languages?
I think that would possibly be stretching that point too far.
If
Mr.
you've got
Commissioner.
interest, what have you done? Have you applied any school to learn Sotho? Free State is Sotho. Have you done that? What effort have you taken to learn the language except learning vulgar?
No, I didn't learn vulgar. It's just something that you were exposed to over weekends and eventually you just picked it up. But other than that, no, I haven't made any effort to learn an African language.
Because you don't have interest in learning African language.
I simply adopted the view that if I tried, I wouldn't like to or wouldn't believe that I had the necessary skills to conduct a trial or cross-examine or understand the nuances of a language. I believe is something that develops over years.
I'm not asking for, I don't want any of you to learn language for the purposes of conducting trial. We're talking, the question in relation to you learning languages is for the purposes of social cohesion. Not for you to conduct trial in Venda or Shangaan or anything of that sort. It will be a mess. 11 languages. All we are asking is to see a judge that has got interest in reaching out to the people of South Africa as a leader.
I simply adopted the view that language was possibly one of my weaker attributes and I could rather try and reach out in other manners and means.
So you don't have interest in our languages?
I do, but I think possibly it's not that easy, sir. It's just...
No, you judge. I mean, you can't say it's not easy before you even try it. You never tried. You never registered for Sotho language. You never took any effort to learn a Sotho language. And leadership can't say that. Before you even try, you say it's difficult.
I do regret having not done that.
So, do you agree that you lacked judgment in concluding even before you started that it is difficult? That's a lack of judgment for a person who wants to be a judge. You have not tried, yet you concluded it's difficult. Is that not lack of judgment?
You wouldn't be remiss if you said so.
I want you to agree with me. If you don't agree with me, let it be.
No, I don't agree with you.
You don't agree with me?
I don't agree with you that it's a lack of judgment on my part.
It's a perfect judgment.
No. Nobody's perfect around here.
No, I'm saying you not learning our language and concluding that is difficult, even without any attempt to try and learn it, is a very good judgment. Qualities of leadership, amongst others, you admit that in your language you say you concede that, no, well, I think it was lack of judgment to even conclude before I started. You know, if you say to me, I took lessons and I couldn't succeed and I concluded it's a difficult thing, I will accept. Before you start, you even say, this is not an easy subject. For me, it's a lack of judgment.
I think what I was trying to say is that my experience is that as children of 3, 4, 5 years of age, one picks up these languages without studying them. I now regard myself as being of such an age that even if I spent a lot of time in the company of people speaking only this language, I wouldn't pick it up as easily as a child would. And for that purpose, or from that point of view, I think it's far more difficult for me now at this stage in my life. That's all I'm trying to say.
You won't even take an effort because you are too old to even learn this language.
No, I believe it's never
even
too old.
After discussing this with you, conversing it with you, it's not only me, everybody else tried. You still don't see a need to try somehow to learn perhaps Sotho in the context of Free State.
I wish I did.
No, I'm saying after this, would you consider taking some lessons in Sotho?
It can only enrich me as a human being, and yes, why not? Why not? I think what you've really drawn home to me is the extent to which my failure to do so can be interpreted as indicative of something lacking in my makeup as a suitable candidate, and I accept that.
Thank you.
Minister.
Thank you, Advocate Fischer. There is a view that language, culture, and ultimately law are instruments of conquest, subjugation, and control, and that one nation would want to impose its own on a nation it considers to have defeated. Would you agree with that perspective about history?
Yes.
And of course, Roman Dutch law, I'm sure you're aware, does not apply in Holland anymore.
Yes.
Because Napoleon defeated Holland and substituted the common law with the French code and all that. Now, our constitution seems to seek to reverse that in the context of South African history and jurisprudence. Is that your understanding of what the constitution seeks to do in our context as well?
Yes, that I agree with.
Would you therefore agree that it is therefore necessary that legal scholars, jurists, etc., practitioners in the profession should strive to mainstream principles deriving from indigenous law that accord with our constitution in an active way in order to redress this legacy of conquest, if you like?
Unequivocally so, yes.
So would you agree that
if you are an agent of change, and I'm not imposing that on you, you may need to consider actively participating in such an effort by ensuring that firstly you familiarize yourself with the principles that, as I've described, from indigenous law, and strive to be a factor in driving that transformation.
Unequivocally so, sir. Absolutely.
Is it something that you're going to give a thought after this interview, over and above the apparent undertaking to try and learn some indigenous languages the Honorable Malema, Commissioner, suggests to you?
I've got no doubt in my mind that in order to promote the legitimacy of the bench and in fact the whole legal system, it has to be more representative of the values of the population that live in this country. And yes, I think what stands in the way of it is this whole principle of stare decisis, which in fact encourages a lot of practitioners to simply see what was said and done last year or the year before. And I would like to believe, and that is the way I look at things, is to try and push the envelope and think outside the box, realizing that we have to legitimize the bench, failing which whatever orders and judgments are handed down will simply be ignored by the people who have lost all their confidence in a system they don't begin to understand. And we could have a discussion that would last us all night long about experience I've had in this regard, where clients are incredulous about principles and values that have been handed down by the Romans and the Roman Dutch and English law, and saying, but they can't believe that that's what the law says. And I think to myself, well, something's wrong here. We have to fix that. So I believe that that's something that anybody sitting on the bench or aspiring to be on the bench should participate in.
One such principle I'd want to propose to you as a starting point comes from the Sepedi language, and it says, you cannot be a judge in your own cause. Don't you think it would be a beautiful principle of universal application where somebody could start from, perhaps, just as an example?
Absolutely. I hear what you say, and I don't see why we need to cling to something which is tainted by, would I say, objective, subjective, and subconscious perceptions of hurt and pain and suffering. What about how the people on the ground feel? What about what affects them? And I support that kind of initiative unequivocally.
Yeah. There is also a view that the legal profession, in particular, maybe not exclusively, is fraught with persistent remnants, to put it mildly, of racism that continues over 2 decades following democracy, and that results in the exclusion of meaningful participation of those who have been historically excluded. Yes. Has that been your experience?
Absolutely, yes. To give you an example, on a very small scale, and something I've personally encountered, is in unopposed motions dealing with something like default judgments in respect of mortgage repayments. The procedure being that the creditor would approach the court and get judgment by default, and then have to approach the court on papers duly amplified to seek execution. In other words, attachment and sale of the fixed property in terms of, I think it's Rule 46. And I, in fact, I have just thought it's simply improper and cannot be countenanced that that somebody who's been living in a home and paying off the mortgage bonds for 5 or 6 or 7 years is suddenly faced with an arrears. Judgment is taken against that person, and before they know where they are, they've lost their house. And in keeping with judgments that have come to mind, like I think it's the Yafta judgment and the Rand Merchant Bank judgments, I have strived to set out in bullet form certain requirements that I would suggest the banks from now on place before courts in trying to convince the court that it is appropriate to execute and sell. Why we can't address that, why we can't revisit that, why we can't do something as simple as rescheduling. Yes, it flies in the face of what the banks are after, but I think it's something that addresses the needs of the people. You can't have a man lose his house simply because he's 2 or 3 or 4 months in arrears with a mortgage bond he's been servicing diligently for the last 7 or 8 years. And it's something like that that I believe has to be addressed. And I can't see why it can't.
I just for now want to stick with inclusivity in participation by those who have been historically excluded in the past,
yes,
as a way of addressing or redressing the legacy of racial exclusion. Now, in keeping with that objective, don't you think the onus is more on those that continue to enjoy privilege in this regard to take up the initiative themselves to see to the reversal of that status quo, be it by way of approaching their own clients who approach them on the basis of, or prefer them on the basis of their race, to persist on principles of inclusivity as a precondition for providing them with legal work, preferably in an organized fashion, that is the organized profession.
Yes. I think it can be achieved. What I have encountered as a practitioner is that very few people challenge the parameters within which they operate, and they simply accept that this is the way it's been done and this is the way we'll continue doing it. It's a challenge that I enjoy because I always like to think counterintuitively. I like to think that there's always a solution, and we live in a horribly fragmented society. We live in a country with all the potential in the world, but there's so much discrimination, there's so much suffering, there's so much...
Have you ever acted in that line yourself personally, whether individually or as part of a collective, by confronting in that manner? Or is it something that you believe in but have not actively acted out?
What I do, and I continue doing it because I don't know what else to do, other than roll my own sleeves up and go out and do something. I've possibly, to an extent, not endeared myself to a lot of my colleagues, simply because I challenge them often simply in a collegial manner on old entrenched views and values and thought patterns, and say you simply cannot continue to think and reason like this. And that is what I love doing, and I'll continue doing that. As I've said earlier in this interview, as an aspiring judge, I see myself as a servant of the people. I see myself as trying to convince and encourage the person down there that I'm not the enemy. In fact, I'm here to help, and it's something that I would like to be given an opportunity to pursue until the day I stop practicing law.
Thank you, Chief Justice.
Thank you, Minister. I hope we're not going to have others over and above the 2 remaining, because we have 4 candidates still to go through. Let us be thinking about what time to break for dinner, because it looks like we're in for a long haul. I'm worried more about the candidates than ourselves. Acting President Maya.
Enkosi, Chief Justice. Good evening, sir.
Hello. Justice Meyer.
You have practiced in the legal field, first as an attorney, then as an advocate since 1981?
If my memory serves me correctly, yes.
According to your application?
Yes, yes.
Yeah. And you've been acting as a judge intermittently since 1999?
That is correct.
So that's what, about 17 years?
Yes.
At paragraph 6.3 of your application form at page 5, you are asked to list cases in which you've appeared, which you regard as being the most significant, and you listed only three.
Yes.
Do you have any reported judgment to your name in the 35 years that you've been in this field? Either when a case you would have appeared in as an attorney, an advocate, or a case in which you presided as an acting judge?
Of significance, are you saying?
No, any reported judgment at all.
Sorry, I don't think I understand the question correctly. Are you saying, is there any reported judgment in which I appeared either as an attorney or as an advocate?
That you can take credit for? A matter which you argued as an attorney, argued as an advocate, or a judgment you penned yourself as an acting judge?
I'm sorry, Judge Meyer, I don't understand the question.
Yes, please.
This is the question.
Yes.
There are times when you would appear in a matter as an attorney.
Yes, that is so.
And because of the quality of the contributions you all make,
yes,
the judgment stemming from that case ends up being reported. It also does happen as an advocate that you're involved in a matter, and your cumulative contributions result in the judgment in that matter being reported. And there are also times when, sitting as an acting judge, you write the judgment,
yes,
and that judgment ends up being reported in the law reports.
Yes.
Does that apply to you? Has that happened to you? Whether as an attorney, advocate, or judge, and if so, how many such cases can you tell us about?
I see. Sorry, there are several of the cases that appear in my bundle of documents attached to the application nomination form that relate to judgments in which I penned that have been reported in both the South African law reports as well as the Butterworth law reports.
Oh, you did not indicate that in the application form.
I'm sorry. They're actually at the end of the bundle of documents. There
is a bundle of cases,
yes,
but you have not stated if they were actually reported.
I'm sorry. No, there are several of them, yes.
All right. Thank you.
I'm sorry for the misunderstanding.
Okay.
I wasn't too sure what was being got at.
Thank you, Acting President. Commissioner Nkosi Thomas.
Thank you, Chief Justice. Good afternoon.
Good afternoon,
sir. And my question relates to paragraph 6.3 of the questionnaire. And yes, I'd like to focus on your reference. You've given 3 cases as being the most significant cases that you've dealt with, but then you don't tell us why. You don't give us the reasons. Don't tell us why you found those to be significant. Now, you refer to the Chevron principle on non-variation clauses.
Yes.
I mean, that emerges from an old appellate division as it then was, 1964 case.
Yes.
So therefore, when this matter served before the SCA, I assume the whole issue about the non-variation clause, one can't really say that it was res nova. It had been resolved one way or the other by the AD then. So therefore, why therefore did you find it, do you list this case as significant? Why? Did it perhaps infuse the Ubuntu principles, the Napier versus Barkhuizen principles? Just why is it significant? It's significant in terms of jurisprudence and its development.
I think what got me thinking about it, although I was on the winning side, if you could put it that way, in this matter. I think what bothered me and still bothers me to this day is the whole basis on which that principle endures. I'm mindful of the need for legal certainty and contractual certainty, but I'm also mindful of the fact that we live in a very challenging and diverse country, and once again we're possibly seeing what was referred to earlier by the Chief Justice or the Minister as the tentacles of a Roman Dutch and a Roman law principle, once again riding roughshod over the realities of the society we live in, namely where parties contract with each other and one of them conducts him or herself in a certain manner. One simply resorts to what is a principle. It has passed constitutional muster, but I think the debate there is still long from over. I think it's going to be revisited on numerous occasions.
Yes, of course, but I guess the question really is, did this judgment add or contribute to the jurisprudential landscape as we have it? Or you're just telling us that I was involved in a case that applied the well-known Chevron clause?
I think principle. It simply, once again, reinforced that principle, and I think the anomaly about it is that it's something that I still feel uncomfortable about. That's what I'm really trying to say.
Thank you, Chief Justice.
Thank you, Commissioner Nkosi Thomas. Thank you very much for your time, Advocate Fischer.
It's a pleasure, Chief Justice.
You are excused, sir.
Thank you very much.